This video is a step-by-step guide on how to do a Chapter 7 bankruptcy.
If you want to know how to file bankruptcy on your student loans, then go to our website.
Please hit subscribe or like. Thank you.
Chapter 7 Bankruptcy. The process. You're going to need a copy of your credit report, last 60 days of pay stubs, last 2 years of tax returns, and where to file bankruptcy. Credit report. Your credit report gives you a list of debts you owe that was reported. There might be some debts you owe that were not reported, such as medical bills, or liens against your house or car. Very important, some medical bills and liens are not listed on your credit report, so do not forget to put them in your bankruptcy paperwork or they will not be discharged. A lien is a debt that will not allow you to sell the house or car until the debt is paid. Once a year, you can get a free copy of your credit report from the following places: over the internet at www.annualcreditreport.com, by phone at 1-877-322-8228. When you call to get your credit report, you will have to go through a verification process, and then they will mail the report to you by mail at Annual Credit Report Request Service, P.O. Box 105281, Atlanta, Georgia 303485281. Pay stubs. You will also need copies of all pay stubs or other evidence of income you received within 60 days before you filed bankruptcy. If you did not work in the past 60 days, then you have to submit an affidavit saying that you have not worked in the past 60 days. An affidavit is the legal way to swear that your statements are true. You will sign an affidavit document in front of a notary public. You can find copies of an affidavit on Google. Your bank should have a free notary public. We reviewed how to create and the procedure of an affidavit in the motion section. Last year tax return and bank account. You will also need a copy of your last year tax return. The court will also accept tax transcripts from the IRS. You can get a free copy of your past tax returns from the IRS, except for the form called Statement of Social Security Number or Numbers. Make sure that any document you file does not have your full Social Security number. Statement of Social Security Number or Numbers form. Do not submit this form with the other forms. This form is submitted directly to the trustee. Depending on the local rules, you will have to submit this form either before the meeting with the creditors or at the meeting with the creditors. Call the trustee office to find out. Most bankruptcy courts require that you submit pay stubs and tax returns to the trustee assigned to your case rather than filing them with the court. Make sure that any document you file with the bankruptcy clerk does not have your full bank account number. Children. Do not put yours or your children's date of birth on any form unless asked. For any dependent, child under the age of 18, you can only use their initials, not their names, such as Jim Doe would be JD. Your local bankruptcy court. If you do not know where to file bankruptcy, then you can go on the internet at www.uscourts.gov and find the nearest location to where you can file bankruptcy. All bankruptcy courts are not the same, and there can be small differences between them. The small differences are usually regarding the following: local forms, local court rules, number of copies, order of papers, typed or handwritten. Local forms. Some local bankruptcy courts have a few additional forms that they require you to file, and you need to find out if they do and what they are. Local court rules. Some local bankruptcy courts have additional procedures that you have to follow. Some courts require you to file a motion to discharge a lien. Others do not. For example, in Idaho, you have to file a summons and complaint to avoid a lien. In other states, you file motion. And in other states, you only have to list the debt on your paperwork. Number of copies. Some local bankruptcy courts require the original and 1 copy, and others require the original and 4 copies. It's always best to have too many copies instead of not enough. Order of papers. Some courts have a preference for the order in which you submit the papers. There is a lot of paperwork, and the clerks do not like going through all of the paperwork and organizing it. Typed or handwritten. Most will accept either typed or handwritten. Always try to type all the paperwork you submit. You might find a typewriter at the library. However, all the forms are fillable, so you can type all the information into each form using Adobe Reader. Every library has Adobe Reader on their computers, and you can download Adobe Reader for free. When you call or visit the bankruptcy clerk, you should ask the clerk, "What is the name of the court and its district?" Ask for all the paperwork and schedules needed to file a Chapter 7 bankruptcy. If there are any special rules or requirements that you need to know about, ask if they have motion to avoid lien forms, notice of motion to avoid lien forms, and certificate of service. Regarding student loans, ask for all the paperwork and schedules to file an adversary complaint. If there are any special rules or requirements for an adversary proceeding. So, now you know that part of the fun is to visit or call your local bankruptcy court. Our best advice is to visit the Bankruptcy Court Free Help Center. This will save you a lot of time and headaches. I know that you are probably feeling overwhelmed, but this is not as bad as it sounds. Just work on it a little each day, and you should have it done in about 2 weeks. And if you have very little assets, then you will probably be able to complete it in a few days. Forms Introduction. In order to file bankruptcy, you have to fill out 19 to 22 forms, submit them to the bankruptcy clerk, and wait for the court to mail you a letter telling you when to meet with the bankruptcy trustee. After you meet with the bankruptcy trustee, your bankruptcy is done. You can download the bankruptcy forms from the federal court website at www.uscourts.gov. The court updates the forms once a year. Not all of them, just some of them, and you have to use the updated forms. Sometimes the court deletes forms, adds new forms, combines forms, or just change the date on the form. The best place to get the updated forms is from the bankruptcy court's website, the Bankruptcy Court Free Help Center, or the bankruptcy clerk office. The forms will ask you to describe the property you sold or gave away in the past 2 years, property you currently own, money you spent in the last 2 years, your current income and their sources, your current monthly living expenses, and all your debts. They will also want to know about the property that you are claiming as exempt. Married. If you are married and you or your spouse are living together or are filing jointly, you must put down their information, even if their income is 0. If you and your spouse are separated and your spouse is not filing with you, do not include information about your spouse. Personal information. Everything you file with the court becomes a public document, and you do not want the public to know your personal information. You do not want the public to know your children's name, your date of birth, your children's date of birth, your bank account numbers, or your social security number. The documents you send to the trustee assigned to your case will not be considered public documents. Remember, except for the form called Statement of Social Security Number or numbers, make sure that any document you file does not have your full social security number. Plus, do not put anyone's date of birth on any form unless asked. For any dependent, child under the age of 18, you can only use their initials, not their names. Before we get started, make a few copies of each form because you will probably make mistakes. Handwrite the drafts and type the copy that you will submit. You might be able to find a typewriter at the library. Some bankruptcy courts allow handwritten forms. Do not forget to list all your creditors and all your assets. You don't want the court to think you're trying to pull a fast one. Filling out the forms. When filling out these forms, you will not have a case number until after you submit the forms to the court. So, leave this part blank. For any questions that do not apply, put 0 or non-applicable as your answer. If the court does not have a district, then leave that part blank. We're not going to go over the forms we think are self-explanatory, such as application and order to pay filing fee in installments, or statement of Social Security number form. Very important, before you submit the form statement about your Social Security numbers, ask the bankruptcy clerk office if you should mail this form to the trustee or file it with the clerk. List of forms. Remember, you can download all the forms from www.uscourts.gov. Some of the following forms we have already mentioned. However, the following is a complete list of all the forms that are needed. The following are the forms you will need for a Chapter 7 bankruptcy. 122A1. Chapter 7. Statement of Current Monthly Income. 122A1. Supp. Statement of Exemption from Presumption of Abuse under Section 707B2. 122A2. Chapter 7 means test calculation. Form 101. Voluntary Petition for Individuals Filing for Bankruptcy. Form 121. Statement of Social Security Number. Exhibit D. Compliance with Credit Counseling Form, Certificate of Credit Counseling. Debtor Certificate of Completion of Post-Petition Instructional Course Concerning Personal Financial Management. Personal Financial Management Certificate. Schedule A and B Property. Schedule C. The property you claim as exempt. Schedule D. Creditors who have claims secured by property. Schedule E/F. Creditors who have unsecured claims. Schedule G. Executory contracts and unexpired leases. Schedule H. Your codebtors. Schedule I. Current income of individual debtors. Schedule J. Current expenditures of individual debtors. Summary of your assets and liabilities, and certain statistical information. Statement of financial affairs for individuals filing for bankruptcy. Notice to individual consumer debtor. Certification of notice to individual consumer debtor. Declaration about individual debtor schedules. Statement of intention for individuals filing under Chapter 7. Application and order to pay filing fee in installments, or application to waive filing fees. We know that this seems like a lot, but it's not as bad as it sounds. The forms. Credit counseling. When you submit your paperwork to the court, you must have completed the required credit counseling class and submit your certificate of credit counseling with Form Exhibit D, individual debtors' statements of compliance with credit counseling requirement. This is very important. You must submit with your paperwork your certificate of credit counseling. If you do not do this, your case might be dismissed, and you have to begin all over and repay the fees. The class costs between $25 and $50. Depending on the company that is providing the class, you can do it over the internet or in person. If you cannot afford the $25 to $50 fee, these companies must provide it for free. Certain requirements will apply. The Bankruptcy Clerk Office or the court's free help center can provide you with the approved credit counseling companies for your state. You can find approved credit counseling classes at www.uscourts.gov/services-forms/bankruptcy/credit-counseling-and-education-courses. You attach the Certificate of Credit Counseling to Form Exhibit D, Compliance with Credit Counseling Form. Remember to make copies of everything you submit in case the clerk loses it. Personal Financial Management. After you submitted all of your paperwork, you must also complete a Personal Financial Management class. You can find approved Personal Financial Management classes at www.uscourts.gov/services-forms/bankruptcy/credit-counseling-and-debtor-education-courses. courses. The class also costs between $25 to $50. Depending on the company that is providing the class, you can do it over the internet or in person. The company that provided you with the credit counseling class can provide the personal financial management class. If you cannot afford the $25 to $50 fee, these companies must provide it for free. Certain requirements will apply. If the personal financial management certificate is not filed on time, then your case might be automatically dismissed. You might have to begin all over and repay the fees. Thus, just get it done as quickly as you can. In fact, do it before you submit your paperwork and submit the personal financial management certificate with all your paperwork. Attach your personal financial management certificate to the back of the form called Debtor Certification of Completion of Post-Petition Instructional Course Concerning Personal Financial Management. Remember to make copies of everything you submit in case the clerk loses it. Miscellaneous but required forms. These are 3 forms that must be submitted. You can download these forms from the federal court website at www.uscourts.gov. The 3 forms are: 1. Certification of notice to individual consumer debtor or debtors. 2. Notice to individual consumer debtor. 3. Declaration about an individual debtor's schedules. When you submit your paperwork, you must submit the form called Certification of Notice to Individual Consumer Debtors, and attach to the back of this form, Notice to Individual Consumer Debtor. This lets your creditors know that you are filing bankruptcy. You must also submit the form called Declaration about an Individual Debtor's Schedules. You do not attach this form to any other form. These forms are self-explanatory, so we are not going to review them. The forms we will begin with are Voluntary Petition for Individuals Filing for Bankruptcy, 122A-1, Chapter 7, Statement of Current Monthly Income, 122A-1, Statement of Exemption from Presumption of Abuse under Section 707B2, 122A-2. Chapter 7 means test calculation. You will need the information on these forms too. Number 1. Determine if you can file for a Chapter 7 bankruptcy. 2. Fill out 22A-2. Chapter 7 means test calculation. Form 101. Voluntary Petition for Individuals Filing for Bankruptcy. This form starts your bankruptcy. You can file all the other forms, but your case will not begin until this form is filed. It is best to file all the forms at the same time so that your bankruptcy will run smoothly. Once you file this form, you have 14 days to file most of the other forms. If you do not do so, your case may be dismissed. Once you file your bankruptcy petition, an automatic stay is in effect. The automatic stay protects you from all collection activities, garnishments, and lawsuit proceedings that your creditors would otherwise attempt. They must stop all collection efforts at once and cannot contact you in any way, except through the court and your attorney. However, the bank may still have the right to foreclose a home mortgage or repossess an automobile. Remember, you must submit with your petition your certificate of credit counseling. If you do not do this, your case might be dismissed, and you might have to start all over and repay all the fees. The rest of this form is self-explanatory. Form 122A-1, Chapter 7, Statement of Your Current Monthly Income. This form is the first step to see if you can file a Chapter 7 bankruptcy. We are only going to review the parts of this form that are not self-explanatory. This form calculates your average monthly income for the past 6 months. Important: for current average monthly income, do not put down income from Social Security, Social Security disability, or some other kind of disability payments. Please see 11 U.S.C. Section 101, 10A, B for more details. On Form Schedule I, Your Income, question number 8 is where you put down income from Social Security, Social Security disability, or some other kind of disability payments. Form 122A-1, Chapter 7, Statement of your current monthly income. This form calculates your average monthly income for the past 6 months. For example, you work 3 months out of the past 6 months. During this time, you earned $1,000 per month. Then your average monthly income for the past 6 months would be $3,000 divided by 6, or $500. For some, Part 1, Question 2, and Part 2, Question 12 does not reflect their true yearly income. It only reflects their past 6 months of income, which is too high, which can deny you being able to file a Chapter 7 bankruptcy. For example, if you are working a seasonal job, your yearly income might only be $18,000, but for the past 6 months, your income might reflect $18,000. For the rest of the year, your income drops to zero, or you collect unemployment. Put down the $1,500, $18,000 divided by 12 months. You will be able to explain in Question 43 on the Form 122A-2, Chapter 7 Means Test Calculation. Question 13. You have to go on the internet to find the answer to this question. The website is www.justice.gov/UST/means-testing or www.justice.gov/UST/BAPCPA/means-testing.htm. Question 14. Box 1. If you check this box, then you are free to file a Chapter 7 bankruptcy. Go to the top of this form and check the box at the top labeled, "There is no presumption of abuse." Plus, you don't have to fill out Form 122A-2, Chapter 7 Means Test Calculation. Box 2. If you check the second box, you are not free to file a Chapter 7 bankruptcy. Now, you must fill out the form called 122A-1, Supp, Statement of Exemption from Presumption of Abuse under Section 707B2. Go to the top of this form and check the box at the top labeled Presumption of Abuse. The form called 122A-1, Supp, Statement of Exemption from Presumption of Abuse under Section 707B2 will ask if most of your debts are from consumer debts. This means your debts are credit card debts, car loans, mortgage, debts for personal, family, or household purposes. Then, you are not free to file a Chapter 7 bankruptcy. Now, you will have to fill out Form 122A-2, Chapter 7 Means Test Calculation. Unless you have a business, then almost all of your debts will be consumer debts. Form 122A-2 Means Test Calculation will figure out if you can or cannot file a Chapter 7 bankruptcy. This form calculates your monthly disposable income. We will review Form 122A-2, Chapter 7 Means Test later. If this Form 122A-1, Chapter 7 Statement of your current monthly income indicates that there is a presumption of abuse, then you might be able to offset it in Question 31 on the Form 122A-2, Chapter 7 Means Test Calculation. One of the things people use to increase their expense is Form 122A-2, Chapter 7 Means Test Calculation. Question 31, Continuing Charitable Contributions. However, you must be able to prove that you have been making the donations regularly and for a long period of time as an ongoing monthly expense. A sudden increase in your charitable contributions will be suspicious and likely to be viewed as fraud. Your contributions cannot be above 15% of your gross income. Military service. If you are in the military on active duty, then you will be able to file a Chapter 7 bankruptcy. However, they keep changing the definition of what it means to be on active duty. To see if you qualify for active duty, fill out the Form 122A-1, Supp, Statement of Exemption from Presumption of Abuse under Section 707B2. The rest of this form is self-explanatory. Form 122A-1, Supp, Statement of Exemption from Presumption of Abuse under Section 707(b)(2). This form is self-explanatory. However, you must file this form with Form 122A-1, Chapter 7, Statement of Your Current Monthly Income.
Please hit subscribe or like. Thank you.
Form 122A-2, Chapter 7, Means Test Calculation. We have now completed the forms required to fill out Form 122A-2, Chapter 7 Means Test Calculation. You only have to complete this form if Form 122A-1, Chapter 7 Statement of Your Current Monthly Income indicated to do so. Most of this form is self-explanatory, but we will review the parts that are not so obvious. A Chapter 7 bankruptcy can be denied if most of your debts are consumer debts, and the court finds that you have enough income to repay these debts under a Chapter 13 bankruptcy. However, if you can show special circumstances that reduce your income or increase your expenses, then you can file a Chapter 7 bankruptcy. This form is where you show you have those special circumstances. Charitable contributions. Your contributions cannot be above 15% of your gross income. One of the things people use to increase their expense is Question 31, continuing charitable contributions. However, you must be able to prove that you have been making the donations regularly and for a long period of time as an ongoing monthly expense. A sudden increase in your charitable contributions will be suspicious and likely to be viewed as fraud. Proof can be a letter from your church, payroll deduction, or bank statement. Make sure that your answer for Question 31 matches what you put for Question 14 on the form called Schedule J, your expenses. Questions 1, 2, and 3 are referring to Form 122A-1, Chapter 7, Statement of Your Current Monthly Income. To answer questions 6 through 15, 30, and 36, go to the following website, and on the website, go to the section labeled Data Required for Completing the 122A Forms and the 122C Forms. Look for the time period that you are filing your bankruptcy. You can also ask the clerk for this information. The website is www.justice.gov/UST/means-testing or www.justice.gov/EO/BAPCPA/means-testing.htm. However, if you live in Alabama or North Carolina, the administrative expense multiplier mentioned in Question 36 can be found at www.uscourts.gov/services-forms/bankruptcy/trustees-and-administrators. Or you can call the following phone numbers and get the administrative expense multiplier from the bankruptcy trustee. Northern District of Alabama, 205-714-3830. Middle District of Alabama, 334-954-3900. Southern District of Alabama, 251-441-5433. Eastern District of North Carolina, 919-334-3885. Middle District of North Carolina, 336-358-4170. Western District of North Carolina, 704-350-7587. Question 36. Question 36 asks, are you eligible to file a case under Chapter 13 if your unsecured debts are below $360,475 and secured debts are below $1,081,400? Then you are eligible to file a case under Chapter 13. Thus, the answer to this question is almost always yes. Thus, if you're rich and own $1 million house and a $10 million yacht, then you have to file for Chapter 7 bankruptcy. If you live in a state like Florida, you get to keep your $1 million house. Because of this, it is our opinion that this is a trick to try and force you into a Chapter 13 bankruptcy. The court cannot force you into a Chapter 13 bankruptcy. All the court can do is deny you a Chapter 7 bankruptcy. They will deny you a Chapter 7 bankruptcy if the court believes that you have enough money to pay debts such as credit cards, and if you can cut back on debts such as your cable bill and still maintain a minimal standard of living. Therefore, where it says projected monthly plan payment, if you were filing under Chapter 13, you can put down 0. Whatever amount you put down, the court will think that you have that much extra money available each month. In order to help ensure that the court does not deny you a Chapter 7 bankruptcy, then you have to make sure the results of Question 37 are equal or bigger than the number you put down for Question 36 regarding the statement projected monthly plan payment if you were filing under Chapter 13. Remember, projections are not always correct or even accurate. Question 40. If the results of Question 40 are, there is no presumption of abuse, then answer Question 36 by checking the box labeled Yes. Then, put as your projected monthly plan payment what you put for line 39C. If the result of Question 40 is, there is a presumption of abuse, then answer Question 36 by checking the box labeled Yes, and then complete Question 41 and 42. Question 41. To answer Question 41, you must stop and now fill out all the other forms. After you filled out all the other forms, then come back and answer Question 41. Question 42. If the result of Question 42 is, there is no presumption of abuse, it means that your disposable income is less than 25% of the total amount of debt you put on the form Schedule E/F, creditors who have unsecured claims. Now, go back and answer Question 36 by checking the box labeled Yes. Then, put as your projected monthly plan payment as 0. If the result of Question 42 is, there is presumption of abuse, then complete Question 43. Question 43. One way to answer Question 43 is the following. Example 1. Let's say that you're working a seasonal job and are being paid $4,000 per month. However, this is only for 6 months. This makes it look like your yearly income is about $48,000, when in fact, your yearly income is only about $24,000. If you are single with a yearly income of $48,000, then you will probably not be able to file a Chapter 7 bankruptcy. But if it's only $24,000, then you will be able to file a Chapter 7 bankruptcy. Example 2. My house needs repairs, and it's starting to get to the point where it's unsafe. My income is XXX per month. I am saving XXX per month for the repairs. The cost of the roof is XXX amount. The electrical cost is XXX amount. And the doors are XXX amount. I cannot find a home loan that I believe that I could afford. You will have to provide some kind of proof that the repairs will cost this much. Example 3. I have an old car. I cannot afford a new car, and I cannot afford to be without a car. So I save XXX per month in case my car breaks down and I have to get it repaired. Example 4. In year 2 XXX, I got sick and could not work for 2 weeks. Because of it, I fell behind on my rent. So in case this happens again, I save XXX per month to make sure that I avoid eviction. Yes, these are nonprofits that can help if one falls into this kind of situation. But this does not mean that these nonprofits will have any money when I need their help. The rest of this form is self-explanatory. After filling out the forms 122A-1, Chapter 7 Statement of Current Monthly Income, 122A-1, Statement of Exemption from Presumption of Abuse under Section 707B2, 122A-2, Chapter 7 Means Test Calculation, you now know if you can or cannot file a Chapter 7 bankruptcy. If you can file a Chapter 7 bankruptcy, then fill out the rest of the required forms. Form Schedule I, Your Income. Schedule I asks about the income that you are receiving now, today. The other forms ask about income you received over the past year. Thus, the income you receive today might be 0, while the income you received over the past year might be $50,000. Thus, the income you report on Schedule I may be different from the income you report on other bankruptcy forms. Question number 8 is where you put down income from Social Security, Social Security disability, or some other kind of disability payments. For question 11, it's asking if anyone else is giving you money to help you pay your bills each month, and how much are they giving you. For most people, this will be 0. If you cannot count on someone else 100% to help you pay your bills each month, then put 0. Form Chapter 7, Statement of your current monthly income, Official Form 122A-1. Use a different definition of income and apply that definition to a different period of time. The rest of this form is self-explanatory. Form Schedule J, your expenses. Question 2. On the part that states dependents, do not put the names for people under 18 years old, such as Jane Smith would be JS. Plus, do not put your date of birth on any form unless asked. On question 20, do not include expenses for your residence or for any rental or business property. You've already listed expenses for your residence on lines 4 and 5 of this form. You listed the expenses for your rental and business property as part of the process of determining your net income from that property on Schedule I, line 8A. Plus, one of the things people use to increase their expense is question 14. However, you must be able to prove that you have been making the donations regularly and for a long period of time as an ongoing monthly expense. 6 months. A sudden increase in your charitable contributions will be suspicious and likely to be viewed as fraud. Your contributions cannot be above 15% of your gross income. Proof can be a letter from your church, payroll deduction, or bank statement. Make sure that your answer matches what you put for question 14 on this form. Schedule J, your expenses. To question 31, continuing charitable contributions, on the form 122A-2, Chapter 7, means test calculation. The rest of this form is self-explanatory. Schedule A and B property. For each question, report the current value of the portion of the property that you own. When you cannot find the value from a reputable source, such as a pricing guide for your car, estimate the value and be prepared to explain how you determined it. Make sure that the values you report on this form matches the values you report on Form Schedule D, creditors who have claims secured by your property, and Schedule C, the property you claim as exempt. Community property states are Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Puerto Rico, Texas, Washington, and Wisconsin. However, the law assumes joint ownership and joint debt unless you can prove otherwise. Community property is property acquired during the marriage, except for gifts or inheritances. Community property is owned jointly by both spouses and is divided upon divorce, annulment, or death. Fee simple means that you have full and irrevocable ownership of the land and any building on that land. Tenancy by the entirety means that each spouse has an equal and undivided interest in the property. Life estate is when a parent transfers the property to a child for the life of the child. It stops the child from selling the property before the child dies. Property you own includes property you have purchased, even if you owe money on it, such as a home with a mortgage or an automobile with a lien. Current value or market value is how much money you can get if you sell the property. You can find the market value of almost any car in the Kelley Blue Book. You can get a copy of the Kelley Blue Book at any public library or on the internet at www.kbb.com. If more space is needed, attach a separate sheet to this form, and on the top of each page, write your name. The rest of this form is self-explanatory. Schedule C, the property you claim as exempt. Use the property you listed on the form called Schedule A/B property as your source to fill out this form. One of the most important parts of any bankruptcy are the exemptions. Exemptions are important because they will allow you to keep certain items, such as a car, tools for work, money in your checking or savings account, etc. Types of exemptions. There are 3 types of exemptions. 1. State exemptions. 2. Federal exemptions. 3. Federal non-bankruptcy exemptions. Some states only allow you to use state exemptions. Some states only allow you to use federal exemptions. And some states will allow you to use either state or federal exemptions. For the states that allow you to use either state or federal exemptions, you can only use one or the other. You cannot use both. You cannot mix and match both. If you attempt to use both, or attempt to mix and match both, your bankruptcy might not go through. So don't do it. However, if you use state exemptions, you can add them to the federal non-bankruptcy exemptions. Homestead exemptions. Homestead exemptions allows you to keep the equity in your home. If the court sells your house to pay your debt, they must pay you the equity before they use the money to pay your debts. What some have done is move to Florida, where there is no limit on the homestead exemption. They will buy a $1 million house for cash, wait 3 years, and then file bankruptcy. They get to keep the house, and after their bankruptcy is complete, they sell their house and collect the cash. This is only for the rich. In New York, the homestead exemption is $50,000 to $150,000. And this depends on where you live. However, this can change year to year, so check first. In Illinois, the homestead exemption is $15,000, but can double to $30,000 if you are married. However, this can change year to year, so check first. Some states have special provisions. For example, the Illinois statutes have a special provision that allows a surviving spouse to protect the full equity of the home if one spouse dies, for as long as the surviving spouse continues to live in the home. Similarly, if a homeowner passes and has children under the age of 18 years old, the children can protect the equity in the home until age 18. If a home is left to a surviving spouse, that person moves out and abandons the home, leaving at least one other person living in the home. The remaining person can continue to protect the equity in the home as long as he or she lives there. Thus, if you're going through a foreclosure, you need to protect the equity you created, or just need to protect your rights. We recommend that you talk to a bankruptcy lawyer before you file bankruptcy. Married exemptions. If you are married and are filing jointly, one cannot pick state while the other chooses federal. You both have to use the same exemptions, either federal or state. However, for some states, if the husband and wife are filing jointly, the exemption can double. This means instead of only being able to keep $1,000 in cash, you will be able to keep $2,000 in cash. Retirement exemptions. If you have some kind of retirement account, talk to a bankruptcy lawyer first, or use exemptions to protect the money you have in these accounts. If you do not use the exemptions, then the court will take the money out of these accounts and use it to pay your creditors. Plus, you might have to pay taxes on the money the court took out of these accounts. In some states, you can have an unlimited amount of money in your retirement account. In other states, it can depend on how much money you put into your retirement account each year. Wildcard exemptions. These are exemptions that can be applied to almost anything you own. For example, if the homestead exemption only allows you to keep $15,000 of equity in your home, and the wildcard exemption is $2,000, then you can add the wildcard exemption to the homestead exemption. This will now allow you to keep $17,000 of equity in your home. However, make sure that you list the wildcard exemption separate from the other exemptions, and state the property that you are applying the wildcard exemption to. Some bankruptcy courts have free lawyers or a free help center. These lawyers or the help center should be able to provide you with the copy of the exemptions for your state and help you find the exemptions that are right for your case. Ask the bankruptcy clerk where to get the information on exemptions. However, you can start by trying the following websites: www.nolo.com/legal-encyclopedia/bankruptcy-exemptions-state, www.legalconsumer.com/bankruptcy/laws/ www.law.cornell.edu/US code/text/11/522 www.thebankruptcysite.org/exemptions/federal.html. For each property you claim as exempt, you must specify the amount of the exemption and state the specific laws for that exemption. Example: federal. Retirement funds $10,000, 100% of fair market value, up to any applicable statutory limit. 11 U.S.C. Section 522(b)(3). Household goods, $2,000, 100% of fair market value, up to any applicable statutory limit. 11 U.S.C. Section 522(f)(4). Motor vehicle, $4,000, 100% of fair market value, up to any applicable statutory limit. 11 U.S.C. Section 522(d)(2). Put down the full fair market value of the property being exempted up to the amount the law states, even if you think it's not worth that much. Current value or market value is how much you get if you sell the property. Property you own includes property you have purchased, even if you owe money on it, such as a home with a mortgage or an automobile with a lien. A lien is and can be a car title loan. You can find the market value of almost any car in the Kelley Blue Book. You can get a copy of the Kelley Blue Book at any public library or on the internet at www.kbb.com. If more space is needed, then fill out as many copies of Part 2 on this form and attach those pages to the first page of this form. Plus, do not forget to write your name on each page. Some exemptions will depend on the law, such as Medicare, Medicaid, unemployment food stamps, and tax-exempt retirement funds. And tax-exempt retirement funds may be unlimited in dollar amount. The rest of this form is self-explanatory. Schedule D. Creditors who have claims secured by property. Secured debts are debts such as a car loan, car title loan, mortgage, or furniture. It is property that they can take back if you do not pay the debt. Do not leave out any secured debts, and try to list them in alphabetical order. When listing creditors who have secured debts on your property, be sure to include all of them. This can include 1. Contractors or mechanics whom have liens on property you own because they did work on the property and were not paid. 2. Someone who won a lawsuit against you and has a judgment lien. 3. Another parent or government agency that has a lien for unpaid child support. 4. Doctors or attorneys who have liens on the outcome of a lawsuit. 5. Federal, state, or local government agencies such as the IRS that have tax liens against property for unpaid taxes. 6. Anyone who is trying to collect a secured debt from you, such as collection agencies and attorneys. A property can have one, more than one, or none of the following. You must check the box that best describes the one that applies. Contingent. A debt is contingent on you paying the debt if something happens, such as you co-signing for a debt. Unliquidated. A debt is unliquidated if the value has not been set. For instance, if you were involved in a car accident, the victim may have an unliquidated claim against you because the amount of damages has not been determined. Disputed. A debt is disputed if you disagree about whether you owe the debt. For instance, if a bill collector demands payment for a bill you believe you already fully paid, you may describe this debt as disputed. Current value or market value is how much you get if you sell the property. The property can be both secured and unsecured. For example, if the outstanding balance of a car loan is $12,000 and the car is worth $10,000, then the car loan has a $2,000 unsecured portion. Thus, on the form column A, you would put $12,000. Column B, you would put $10,000. In column C, you would put $2,000. Here is where it becomes confusing. So, instead of explaining, we will just provide examples. You have a first mortgage of $200,000, a second mortgage of $150,000. Thus, the total debt on your home is $350,000. However, your home is only valued at $300,000. This is called being underwater on your mortgage. The value of your home is $300,000, and you have a first mortgage of $200,000. Then the $200,000 would be fully secured with $100,000 of value remaining. You also have a second mortgage of $150,000. From the remaining $100,000 of the previous calculations, you can use this to calculate secured and unsecured portions of this loan. Thus, $50,000 would be unsecured. The results would be for the first mortgage, column A, $200,000, column B, $0, and column C, $0. The results would be for the second mortgage, column A, $100,000, column B, $100,000, and column C, $50,000. Do not repeat the unsecured portion on Form Schedule E/F, creditors who have unsecured claims. On Part 2 of this form, list any others that should be notified about the debt you listed in Part 1. This could be a collection agency, an attorney that is trying to collect, or a cosigner. If you are not sure who the creditor is, then list anyone who has contacted you about the debt. If more space is needed, then fill out as many copies of Parts 1 and 2 of this form and attach those pages to this form. Plus, do not forget to write your name on each page. The rest of this form is self-explanatory.
Please hit subscribe or like. Thank you.
Schedule E/F, creditors who have unsecured claims. Do not put down on this form any unsecured debts you put on Schedule D, creditors who have claims secured by property. Do not leave out any unsecured debts, and try to list them in alphabetical order. Unsecured debts or claims include the following. 1. Your ex-spouse, if you are still obligated under a divorce decree or settlement agreement to pay joint debts. 2. A credit card company, even if you intend to fully pay your credit card bill. 3. A lender, even if the loan is co-signed. 4. Anyone who has a loan or promissory note that you co-signed for someone else. 5. Anyone who has sued or may sue you because of an accident, dispute, or similar event that has occurred. 6. Anyone who is trying to collect a debt from you, such as a bill collector or attorney. 7. Red light or parking tickets. 8. Student loans. Listing student loans on this form will not get them discharged. In order to have your student loans discharged, you have to go through additional court proceedings. There are two types of unsecured debts, and they are priority unsecured debts and non-priority unsecured debts. Priority unsecured debts are 1. Domestic support obligations, such as child support, obligations under a divorce decree, legal guardianship, aged parent or a child, or foster care. 2. Taxes and other debts you owe the government, red light or parking tickets. 3. Claims for death or personal injury that you caused while you were intoxicated. This is only up to $12,475 per person. Any amount above this is non-priority unsecured debt. 4. Deposits for personal, family, or household, such as if you received money from someone for the purchase, lease, or rental of your property, house or car, or the use of your services but you never delivered or performed. This is only up to $2,775 per person. Any amount above this is a non-priority unsecured debt. 5. If you owe wages, salaries, commissions, including vacation, severance, and sick leave pay, and those amounts were earned within 180 days before you filed your bankruptcy, this is only up to $12,475 per person. Any amount above this is non-priority unsecured debt. 6. Contributions to employee benefit plans. This is only up to $12,475 per person. Any amount above this is non-priority unsecured debt. Non-priority unsecured debts are credit card bills, medical bills, and student loans. Putting your student loans on this form will not get them discharged, but the court wants you to list them so they know your whole financial situation. Many have made the mistake of not listing all their medical bills. Whatever medical bill that is not listed will not be discharged. Check the box labeled disputed, because some have discovered that portions of medical bills come in after the bankruptcy is completed. Their insurance did not pay the full amount. If the debt is both priority and non-priority, then list the debt in Part 1 and show both priority and non-priority amounts. Do not list it again in Part 2 or 3. Deposits for personal, family, or household, such as if you received money from someone for the purchase, lease, or rental of your property, house or car, or the use of your services but you never delivered or performed. Any amount above $2,775 per person is non-priority unsecured debt. If you owe wages, salaries, commissions, including vacation, severance, and sick leave pay, and those amounts were earned within 180 days before you filed your bankruptcy, any amount above $12,475 per person is non-priority unsecured debt. Contributions to employee benefit plans. Any amount above $12,475 per person is non-priority unsecured debt. In Part 3, list all of the ones that should be notified about the debts you listed, such as collection agencies, attorneys, etc. Plus, do not forget to fill out Part 4. Remember, you must list every debt. Even if you plan to pay a particular debt, if you do not list a debt, it may not be discharged. If you want to pay the debt, then fill out a Reaffirmation Agreement. We will go over Reaffirmation Agreements later. If more space is needed, then fill out as many copies of Parts 1, 2, and 3 of this form and attach those pages to this form. Plus, do not forget to write your name on each page. The rest of this form is self-explanatory. Schedule G, Executory Contracts and Unexpired Leases. If you have nothing to report in this form, then check the box at the top. You must list all agreements that may be executory contracts or unexpired leases, even if they are listed on Schedule A/B property. Thus, some of the debts you listed on Schedule A/B property, you will also list them on this form. Executory contracts or unexpired leases include the following. 1. Cell phone, internet, and cable contracts. 2. Vehicle leases. 3. Supplier or service contracts. For example, contracts for lawn care or home alarm or security systems. 4. Timeshare contracts or leases. 5. Rent for your apartment. 6. Maintenance fees. Co-op, condo. 7. Rent-to-own contracts. 8. Employment contracts. 9. Real estate listing agreements. 10. Contracts to sell residence, building, land, or other real property. 11. Equipment leases. 12. Leases for businesses or investment property. 13. Supplier and service contracts for your business. 14. Copyright and patent license agreements. 15. Development contracts. If more space is needed, then fill out as many copies of Part 2 and attach those pages to this form. Please do not forget to write your name on each page. The rest of this form is self-explanatory. Schedule H, your Codebtors. To help fill out this form, use both Schedule D, creditors who have claims secured by property, and Schedule E/F, creditors who have unsecured claims. Codebtors include cosigners, guarantor, former spouse, unmarried partner, or joint contractor. If one spouse is filing bankruptcy and the other is not, then for community property states such as Arizona, Washington, Wisconsin, California, Idaho, Louisiana, Nevada, New Mexico, and Texas, your spouse will always be a co-debitor or co-signer for any debt attained during the marriage. If you're filing and your spouse is not, then your spouse is a co-signer if the debt is for necessities such as rent, food, or medical care. However, if you're filing a joint case, do not list either spouse as a co-debitor. If more space is needed, then fill out as many copies of Parts 2 on this form and attach those pages to this form. Plus, do not forget to write your name on each page. The rest of this form is self-explanatory. Form 106, Summary of your assets and liability. and certain statistical information. This form is self-explanatory. Statement of financial affairs for individuals filing for bankruptcy. Question 10 is where you put down any garnishment. Question 11 regarding set-off. Set-off means that I owe you $100 for a chair, but you owe me $100 for a table. The amount I owe you is set off or canceled by the amount you owe me. Another example is I owe you $90 for a chair, but you owe me $100 for a table. The $90 I owe you is set off, but I still owe you $10 debt. If more space is needed, then reference the question on another sheet of paper and attach those papers to this form. Plus, do not forget to write your name on each page. The rest of this form is self-explanatory. Form 121, Statement of Social Security Number or Numbers. Very important. Before you submit the form statement about your Social Security numbers, ask the bankruptcy clerk office if you should mail this form to the trustee or file it with the clerk. This form is self-explanatory. Statement of intention for individuals filing under Chapter 7. This form is required only if you have debts secured by your property, or if you have leased personal property and that lease is not expired. It tells the court and the creditor what you intend to do with that property, such as a car, house, boat, etc. You will need the following forms to fill out this form. Schedule D, creditors who have claims secured by property. Schedule C, the property you claim is exempt. Schedule G, executory contracts and unexpired leases. You can 1. Surrender the property. 2. Retain the property and redeem the property. 3. Retain the property and enter into a Reaffirmation Agreement. 4. Retain the property and explain. Surrender the property. You may surrender the property. If you surrender the property, your bankruptcy will protect you from the difference between what you owe and what the creditors receive from a sale of the property, unless the court determines the debt is non-dischargeable. If you want to keep the property, you may be able to reaffirm the debt, redeem the property, or take other action. We will review reaffirmation procedure later. Redeem the property is not the same as reaffirmation. Redeem the property. To redeem your property, you must file a motion with the court. If the court grants your motion, you pay the creditor the value of the property or the amount of the debt, whichever is less. Thus, if the car market value is $8,000, the debt is $10,000, you pay the $8,000. However, the payment will be a single lump sum payment. If you can make a single lump sum payment, then you probably do not qualify to file a Chapter 7 bankruptcy. Reaffirmation Agreement. Reaffirmation means reaffirming the debt. You may reaffirm the debt in full on its original terms, or you and the creditor may agree to change the terms. If you lease personal property, such as your car, you may be able to continue your lease if the trustee does not take control of the lease. To continue your lease, call or write the lessor that you want to assume your lease. The lessor may, at its option, notify you that it's willing to have you assume the lease and may cancel any outstanding balance or attach the outstanding balance to the new monthly payments. If the lessor notifies you that it's willing to have you assume the lease, you must write back to the lessor within 30 days stating that you will assume the lease. Retain the property and explain. Retain the property and explain means that the property is exempt. Use form Schedule C, the property you claim is exempt, to help fill this out. It could also mean that the property is not worth selling. There could be a number of reasons. You must file this form within 30 days after you file your bankruptcy petition, or by the date set for the meeting of creditors, whichever is earlier. Meeting of creditors is usually within 30 days after you file your bankruptcy petition. Some courts require a certificate of service. We will go over what a certificate of service is in the motion section. A certificate of service is simple to create. For the certificate of service, you can list all of the names and addresses of all the creditors on one document. Thus, you do not have to make a certificate of service for each creditor. You must file a copy of the Certificate of Service and the Form Statement of Intention for individuals filing under Chapter 7. Remember, mail a copy of Statement of Intention for individuals filing under Chapter 7 and a Certificate of Service for each creditor listed on that form. Then attach the Certificate of Service to the original of the Statement of Intention for individuals filing under Chapter 7 form and file these forms with the bankruptcy clerk. The rest of this form is self-explanatory. Reaffirmation Agreement. Reaffirmation means reaffirming the debt. You may reaffirm the debt in full on its original terms, or you and the creditor may agree to change the terms. This also means you will not be able to file bankruptcy on this debt for another 8 years. Therefore, before you agree to a reaffirmation agreement, make sure you can afford the payments. Neither you nor the creditor is required to do a reaffirmation agreement. No one can force you into a reaffirmation agreement. Only agree to reaffirm a debt if it's in your best interest. If you were not represented by an attorney during the negotiation of your reaffirmation agreement, then it will not be effective unless the court approves it. Thus, you will have to file a motion requesting approval from the court regarding the reaffirmation agreement. You may cancel the reaffirmation agreement at any time before the bankruptcy court enters a discharge order, usually 6 months, or within 60 days from the day you filed the agreement with the court, whichever occurs later. To cancel the reaffirmation agreement, you have to do it in writing to both the court and the creditor. Remember, you can cancel the agreement even if the court approves it as long as you cancel within the time limit. If you enter into a reaffirmation agreement, your creditor will usually do most of the work. All you will have to do is copy the terms of the contract to the reaffirmation agreement documents and file them with the bankruptcy court. These documents are the following. You can download these forms from the federal court website at www.uscourts.gov. Form 427, Cover Sheet for Reaffirmation Agreement. Form 2400B, Motion for Approval of Reaffirmation Agreement. Form 2400A, Reaffirmation Documents. B2400A/B, Alt, Reaffirmation Agreement. B2400C, Order on Reaffirmation Agreement. These documents are self-explanatory, so we will not review them. However, there are some requirements that have to be fulfilled before you can enter into a reaffirmation agreement. The requirements are: 1. The reaffirmation agreement has to be voluntary. 2. You must be fully informed of what is in the agreement. 3. The reaffirmation agreement cannot impose an undue hardship on you or your dependents. Make sure we are now done with all the forms. Make sure that you did not leave out any creditors or any debts. Make sure that your answer on Schedule I and Schedule J matches your answers on Form 122A-1, Chapter 7 Statement of your current monthly income, and, if was needed, Form 122A-2, Chapter 7 Means Test Calculation. After you file the paperwork and you find that you made a mistake or have to make changes, then you will have to file an amendment. This means going back and redoing all the forms and schedules that are affected. Plus, pay a $35 fee. No matter what the changes you have to make are, you will have to redo the summary of your assets and liabilities and certain statistical information and declaration about an individual debtor's schedules. Because these two forms are tied to all the other forms and schedules. Remember, it is always better to have too many copies instead of not enough. Make copies because the clerk may lose some of them. Very important. Make and keep copies of anything the court mails to you. We know people that file for bankruptcy, and 5 to 10 years later, they started to get calls from collection agencies on the debt they had discharged. Some collection agencies try a lot of tricks. Before you mail it or drop it off, if you drop off the paperwork, make sure that you get the clerk to stamp the copies you made for yourself. It is best to drop it off yourself so that the clerk can go over it with you and let you know if you made any mistakes. If you mail the paperwork, make sure the type of mail you use provides a delivery receipt. You added extra copies that the clerk can stamp and mail back to you. You include a 9x12 postage prepaid envelope that is addressed to you. Unless you made a mistake, relax. The hard part is now done. If you have a creditor still calling you, just tell them that you have filed bankruptcy. However, the trustee will send them a letter stating that you have filed bankruptcy. Meeting of the creditors. After you file the paperwork, you will receive your case number. Then, call the trustee office and ask where and how to mail the trustee copies of your taxes and 60 days of pay stubs to the trustee. You can find the trustee office at www.uscourts.gov. In addition, you will also receive the time and place where the meeting of the creditors will take place. You must attend this meeting, or your bankruptcy might not go through. Creditors hardly ever show up for this meeting. You should bring 2 forms of ID, where one should have your Social Security number on it. At the meeting, if you made any mistakes on the paperwork, tell the trustee about it before they ask. After the meeting of the creditors, for most people, this is where their bankruptcy is now complete, and all they have to do is wait 2 to 4 more months to receive the discharge papers in the mail. For others, after the meeting, the trustee and the creditors will make arrangements to collect the property that you have to give up, or said that you would give up in your paperwork. If you are reaffirming any debt, then you might have to attend a discharge hearing so that the judge can make sure that this is what you want to do. If you do not have to attend a discharge court hearing, then all you have to do is wait to get the formal discharge papers in the mail, which can take 3 to 6 months. About 1 month after you received your discharge papers, you will start to receive a lot of applications for new credit. They know that now you cannot file for bankruptcy for another 8 years. And because of your bankruptcy, they can charge you a very high interest rate. We know that this all seems very overwhelming, but just take it one step at a time. Work on it a little each day, and you'll be surprised at just how fast you get it all done. We know that these videos have been long, and we thank you for your time and consideration. Good luck. Best of luck.
Please hit subscribe or like. Thank you.